My name is Randy Sparks. I'm a trust and estate attorney at York Howell in South Jordan, Utah.
Okay, what would you say, why would someone need a trust attorney or an estate attorney?
One of the big reasons for estate planning that I like to talk to people about is what we're really doing is choosing who is going to make decisions for you when you cannot make them for yourself anymore.
Okay, so like for me right now, I have a house, I have 2 cars, I have 4 kids, I don't have anything else. You know, I don't need an attorney or I don't need an estate, do I?
I would say absolutely you do.
Okay, why?
Yeah, and the reason for that is there's a lot of decisions. What would happen if you or your wife are incapacitated or pass away? Estate planning is not just about who gets my stuff when I die. It's who can step up and step into my shoes when I'm unable to do it for myself.
Okay.
If I'm incapacitated, who can access my bank accounts and take care of my financial matters? Or who's going to make my medical decisions for me? Or heaven forbid, if I pass away, who's going to be guardian for my minor kids? And if there's nobody appointed for these things, someone has to go to court to go through a process to get appointment for that, and nobody can access assets.
Okay.
Who's going to take care of the kids? They might need to go in foster care in the meantime until somebody's officially appointed as their legal guardian and conservator. And so that's one of the reasons.
So Randy, what's the difference between a will and a trust?
Okay, this is a really good question and it's important. So a will is really awesome. And most people know what a will is because they've watched TV ever in their life, right? But what a will does, it's a legal document that you sign where you get to choose who your executor is going to be, who steps in and takes over your estate after you pass away. And their responsibility is to administer your estate, pay all your final expenses and get all the things. And then so your will appoint who you choose to be your executor, and you might name some alternates. If you have minor children, you'll also name who would be guardians for your minor children.
Okay.
And you get to outline the disposition of your assets. Who gets what and how and when do they get it, right?
Okay.
So that's a will. A will says who's in charge and who gets the stuff.
And that's not enough. Why would you want a trust instead of a will?
Okay, well, a will is going to be great. So first of all, a will is awesome because you get to be the one who clarifies what happens. If you do not have a will, then the default state law says who gets the stuff. It might be the same people that you want, it's just you didn't get to choose who's in charge of it. Somebody has to volunteer and file a probate with the court to go say, well, I'll be the executor, they didn't have one. And then the state law says this is who inherits your stuff, whoever your closest heirs are.
Okay.
And there's a hierarchy of who those heirs are, right? Spouse if you have one. And if you did, they get 100%. If you don't, then it'd be down to children.
Okay.
Equally among the children. But here's the thing, if you don't have a will and everything were to go to your children when you pass away, if they're at least 18 years old, they get it outright. What if you have irresponsible children or children with certain issues, or maybe you didn't want them to get it in a certain fashion? You want to say, well, let's put some parameters around how and when they get it. That's why you want a will, because you can specify those things, slice and dice it.
Okay.
Maybe they get it in staged distributions, for example. And so that's why a will is really awesome. So here's the disadvantage of a will. Even though it's really awesome, right? I advise it to have it. But the will does not avoid going through the court-supervised probate process. And what is probate? Probate is exactly what I just said. It's the court-supervised process to carry out your will or administer your estate.
Which typically is a kind of lengthy process.
It can be, yeah, it can be lengthy, and it consists of having an official executor appointed, which we don't call them an executor in Utah, we call them a personal representative, but it's the exact same thing.
Okay.
And that personal representative is then given the authorization by the court to be able to step in as your executor, and they can then go access your account, sell the house, file your final tax return, take care of all your things, pay all your final bills, and then distribute the assets to who is supposed to receive it.
Okay.
That's the probate process. The probate process can be time consuming, can be expensive, can be contentious, depending, and it's public. All of these filings are public record.
Well, I feel like that'd be a lot of pressure on that one person too, who's now its decision to make all your decisions, right?
Yeah, it can be, and they need to sort that out. Somebody has to administer the estate, and they're the one charged with doing that. So that's a will, and a will is great, right? We're going from not having a will, the least advisable, right? Having a will, way better, because you got to choose what you want, but you don't avoid that court-supervised public process.
Gotcha.
So where does the trust come in?
So that means all your everything open book, right? If it's a will, it's public.
Yeah, your nosy neighbors could look up on the public record and see, well, you know, who got their stuff, who were their heirs, and that's all public record. Every now and again, a celebrity passes away and then their will gets probated, and everybody's all the tabloids are looking
Gotcha.
to see what they are.
Okay. So then a trust, how is that different?
Okay, so trust is a little bit different. And so think of a trust like this. All a trust is legally is a contract between two parties. So, but a trust agreement is a contract between me, I'm establishing the trust, and I am handing over assets to a trustee who says, I agree to hold these assets in trust for your beneficiaries. So let's just imagine that this trust is a bucket. So I create a trust, a bucket during my lifetime.
Okay.
And then I'm going to put my stuff into that bucket. I will title my home into that bucket. I deed my home into the trust.
Okay.
The trust can be named as the beneficiary of my life insurance policy or my bank account or the owner. So I get all my assets into this bucket during my lifetime. And we call it a living trust for that. And then I hand this bucket to a trustee who says, okay, I will hold this stuff in trust for your beneficiary. Well, the way that a revocable living trust works like this is I create the trust and I am the trustee of the trust.
Okay.
So while I'm alive, I'm holding my own bucket for myself during my lifetime. But why does that matter? Number one, a will only becomes like enforceable after I pass away,
Yeah.
right? And it has to go through probate to carry it out.
Okay.
A trust is actually enacted while I'm living, and everything's in the trust in the meantime. So while I'm alive, I'm in charge of everything. I'm the trustee, I'm the signer on the accounts. My job is to use the money and assets for myself, right? It's kind of business as usual,
Yeah.
living my life the way I normally would have. But if I'm incapacitated, but I'm still living, the purpose of the trust is to use the assets for me for the rest of my lifetime. But it's really smooth in capacity planning because I've named a successor trustee who can walk in and pick up that bucket without having to go to court to get approval to do so.
Gotcha.
So they can take over all those assets for my benefit while I'm still living. So it's not just who gets my stuff when I die.
Gotcha.
It's who can step in and how easy can they do that during my lifetime.
Gotcha.
Right? So my wife and I have a joint revocable trust that we've created together. If I'm incapacitated, she remains the other trustee and she can still control everything. But if she's incapacitated, we've named a successor to step in and pick that up to take it.
Gotcha.
So that's phase one. Phase two is, after death, then that successor trustee can come in and says, okay, well, we've got all their assets in here without going through the probate process.
Okay.
The trustee can pay our final expenses.
It's
and
done.
administer the assets. I mean, they still have to go through the steps of, do I need to sell assets or pay the bills?
Time-wise and money-wise in probate, as they're trying to get stuff through court, it's already taken care of.
Yeah, they don't need to go through probate. There's no probate at all. The trustee, so nothing in the trust has to go through the probate process. So it's very important that we get the assets into the trust
Because everything's in its own bucket already set up.
Right. And so the successor trustee can just step in and say, okay, well, I've got the bucket. And my responsibility is to administer these assets the way that I outlined. And so the trust is going to say what the will normally would have of, this is who is going to get the stuff and how and when they're going to get it.
Okay.
And then that's where everybody can be really unique and specific in how they design their own trust.